I would like
Sure.
to wish you
Please.
all a very happy 75th Independence Day. And let's hope that this year also brings peace and harmony amongst all of us and all the citizens of India. Now, the topic which has been given to me today is alternate dispute resolution. Now, why, first of all, we had the need of this? As we all are aware that the nature of disputes were such that they were inherently inevitable and could not be resolved amicably. Therefore, the parties resorted to the courts, and which led to heavy pendency of the litigation in the courts, which was costly and also time-consuming process. The government of India therefore thought that we should introduce alternate mechanism for resolving the disputes. And this new system is known as alternate dispute resolution system. Dispute resolution is a vital development for making social life peaceful. As the name suggests, it is an attempt at providing an alternate to the conventional methods of resolving disputes, which seems to be gaining popularity globally as well as domestically because of the successful execution of the system. This system is flexible as opposed to litigation, wherein methods can be taken to resolve their disputes at their own terms and expeditious and at a lower cost. ADR, as we say, aims to provide inexpensive, as said by Mr. Somnath also, inexpensive, speedy, and a more flexible remedy, and thus makes for a viable substitution for litigation. As we are also aware that the incorporation of Section 89 and Order 10 of the Code of Civil Procedure 1908 was a radical step towards the promotion of such mechanism in India. Section 89 basically talks about settlement of disputes outside the court. It is now obligatory for the courts to refer the matter for settlement with the concurrence of the parties in the following methods, which we have now. 1, arbitration. 2, conciliation. 3, judicial system, including settlement through lok adalats, and mediation. Now, these various methods forming part of alternate dispute resolution mechanism in India may be, as said, classified first as arbitration. Now, arbitration, we were governed earlier by the Arbitration Act 1940. So under that act, there was no time limit for passing an award by the arbitrators. And after the award was passed, it had to go to the court for making it as rule of the court. That was a time-consuming process. And so the need was necessitated for repealing that act, and then came the new act, which was known as the Arbitration and Consolation Act 1996. So under that act, you see, it was a technique. Arbitration, as we say, is a form of an ADR, a technique for the resolution of disputes outside the court, where parties to the dispute refer it to one or more persons who are known as arbitrator or arbitrators, by whose decision they agree to be bound. So as such, when parties agree to have their disputes decided with the mediation of a third person, but with the formality of a judicial adjudication, they may, broadly speaking, be called an arbitration. Any dispute arising out of a defined, I said defined legal relationship can be resolved through arbitration. It can be either voluntary or mandatory. So under the new Arbitration and Conciliation Act, the time fixed for passing an award is 1 year. Time period has been fixed, which can be extended mutually by 6 months and then further by 6 months. The award passed by the learned arbitrator is final. It can only be challenged by way of filing objections under Section 34 of the new Arbitration and Conciliation Act. Arbitration also is adversarial, and a third party arrives at a decision that is binding on both the parties, and thus, I say, it bears the most resemblance with litigation. So now, coming next to mediation, under the civil procedure, alternate dispute resolution and mediation rules, mediation is one which facilitates discussion between the parties, assists parties in identifying issues in dispute, reduces misunderstanding, clarifies priorities, generating options in an attempt to solve the dispute and emphasizing, word is emphasizing, that it is the party's own responsibility for making decisions which is different from arbitration, in the sense that mediation means the intervention of some neutral third party, which is called a mediator, with the intention of resolving the dispute, who does not impose his decision. Thus, mediation is not binding on the parties unless they mutually and voluntarily decide or choose with it. Now, mediation is a process which is based on confidentiality and neutrality. The mediator is an independent and a neutral person. The mediator cannot impose anything upon the parties. Whatever is decided is entered into the settlement deed. The settlement deed is forwarded to the court, and the court, thereby based on the settlement, passes a decree which becomes final and can be executed if the person does not obey or does not want to go ahead with that. In mediation, we generally cannot write anything against the parties. It is basically consisting of, I should be saying, non-starter, not settled, and settlement. Non-starter is one where a party given an opportunity appears or does not appear at all, appears once or twice, but it doesn't reach any conclusion, so the matter is sent back as non-starter. Not settled, where the party appears, but the matter cannot be settled, so it is not settled. And settlement, where the parties agree and the matter is settled and the terms and conditions are reduced into writing. So that becomes a valid settlement and can be executed and can be acted upon by the parties. Now, there is another form of mediation which has recently come up, is a pre-litigation mediation. Pre-litigation mediation is one where parties are having dispute and they opt to, they are thinking of going to the courts, but then they say, instead of going to the court, I should give it a try by way of going before the mediation center by way of filing this pre-litigation mediation. So in the pre-litigation mediation, when we file an application, the procedure which is followed is again the same as it is in the mediation. The parties are called upon to appear. The defendant appears, and it is basically a win-win situation for both the parties in this case, because a person who wants to go to the court has restrained himself, and the other person who could have been made to come to the court is also delayed by going to the court by way of coming before the mediation pre-litigation center. So in that also, once the pre-litigation matter is settled, that is reduced into writing. The settlement deed once entered, again, if the one party does not come forward to adhere to the settlement, the aggrieved party can again approach the court and get that order executed. Now, hereafter, we come to conciliation. Now, the conciliation is an alternate dispute resolution process whereby the parties to dispute pursue a conciliator who meets with the parties separately in order to resolve the differences. And conciliation again is a voluntary proceedings under the civil procedure, alternate dispute resolution and mediation rules. Conciliation has been defined as the process by which a conciliator who is appointed by parties or by court applies the provision of Arbitration and Conciliation Act, because it is under the Arbitration and Consolation Act, insofar as they relate to conciliation, and in particular make proposals for settlement of the disputes and formulate or reformulate the terms of a possible settlement. So conciliation and mediation are different from each other in various respects. One community between both suggests that both depend on the will of the parties. In conciliation, the conciliator does not decide for the parties, but only brings the parties to an agreement through negotiations to find a solution that is compatible to both. Please see, it is compatible to both. Thereafter, we now come to the third, which is Lok Adalat. So Lok Adalat, as it is known as People's Court, and is presided over by a sitting or retired judicial officer as chairman, with two other members, usually a lawyer and a social worker. There is no court fee, thus it effectively caters to the financial vulnerable sections of the society. Nowadays, we are having permanent Lok Adalats also, and other Lok Adalats which are being set up by the Delhi Legal Services Authority. Matters are being referred to the Lok Adalat. Now, all types of methods, be it criminal or civil or family, are referred there. Once the matter is referred to the Lok Adalat, matter is settled, where the Lok Adalat passes a necessary decree therein. The decree so passed will attain finality. That decrees are passed with the consent, the orders or judgments or settlements are taking place with the consent of both the parties. And then they are referred to the court. The court is then passing the decree, which becomes final. So Lok Adalat are especially effective in settling nowadays. They are settling money claims, dispute like partitions, damages, matrimonial, and check bouncing cases are also being referred to the Lok Adalats these days, as scope of compromise is broader. I myself had an opportunity to be a judge in one of the Lok Adalats where the matters were pertaining to motor accident claims. And I think on that very day, we must have settled, our bench must have settled about 30 to 40 matters of motor accident claim, and parties were very happy that it is a very easy process. Time has been saved, money has been saved. So now we come to the advantages of alternate dispute resolution mechanism. One, it is informal and flexible. Two, it is cost effective. Three, more convenient. And five, efficient and less time consuming. You must have heard about the commercial courts. These days, the commercial courts, commercial division and appellate commercial division of High Court Act, which was a Commercial Courts Act 2015, was also passed. I think it was by notification dated 31st December 2015. The scope and activities which were falling under the definition of commercial under the Act have been kept wide and inclusive. The primary object behind the enactment of that Act was to fast track the disposal of commercial cases owing to the huge amount of money at stake. Then the objective was in harmony and its policy of ease of doing business. The government of India amended the Principal Act wide the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Amendment Act of 2018, which was notified on 21st of August 2018. So one of the key features of this amendment was that the pecuniary jurisdiction of commercial courts under the Principal Act was reduced to which shall not be less than Rs 3 lakhs, which earlier stood to which shall not be less than 1 crore. However, the leading landmark facet of this amendment was the insertion of section 12A under this act, which shall not be substituted unless the plaintiff exhausts the remedies of pre-institutional mediation in accordance with the rules, meaning thereby under this act, pre-institutional mediation, as we say, pre-litigation mediation, pre-institutional litigation was made mandatory before going to the courts. The fundamental intent of the legislature behind this provision was to emphasize on the importance of an alternate dispute resolution mechanism that exists in the society. The mediation is carried out as per the provision of the Legal Services Authorities Act 87, 1987, and the same timeline as is applicable for resolution of disputes, that is in the mediation process, shall be complete within a period of 3 months from the date of application by the plaintiff, and in case the parties fail to arrive at a settlement, mediation may be extended for a period of 2 months with the consent of the parties. So this is very important, 3 months or 2 months extension. It has to be completed within a period of maximum 5 months. So on account of the easing of the courses of transition and to facilitate smooth application of the law, the central government correspondingly notified the commercial courts pre-institution of mediation and settlement rules 2018, wide notification dated 3rd July 2018. Now, mediation has also become very common, it's rather become a need of the hour. And the enactment of the Companies Act 2013 also saw the formal inclusion of mediation and conciliation wide section 442 of the Companies Act 2013, which empowers the central government to maintain a panel of experts to be called as a mediation panel. So in the banking institution, in this company's institution also, we can approach for mediation. So that scope has been also widened. So now coming to the fact that there was all these things were going on. However, we were struck by the pandemic, COVID-19 as it is known. the impact of this pandemic on this world has already, I think, surpassed the impact of almost any other crisis in the history. Terms like lockdown, social distancing, and quarantine have attained normality. The global coronavirus pandemic has promptly and assertively changed the approach of the courts in relation to civil litigation because of the fact that the courts have remained closed or due to lockdown, and because of the fact that people could not appear in the courts. They were afraid to appear. The world's population living under lockdown conditions, clients, their advisors, and judicial and arbitral bodies worldwide now find themselves in an exceptional circumstances. Courts around the globe have resorted to the COVID-19 outbreak by delaying or altogether suspending proceeding, as we are seeing in our country also, while some courts have made attempts to use technology such as outlining appearances by video conference to other have chosen to defer proceedings deemed non-essential. Prior to COVID, courts were overwhelmed with clogged schedules, shortage of judges, drained support staff, and simply a lack of time for judges to engage the parties in settlement discussions. So what happened now? Because of this, we have come up with an online dispute resolution, which is known as ODR, the future of ADR. The extraordinary circumstances of 2019 novel coronavirus, as we put it, rapid spreads are felt everywhere. The crisis has forced a change in the way people look at dispute resolutions, and the courts, tribunals, and other various dispute resolution bodies are no exception. Hearings are being postponed, and matters that once would have addressed in persons are now being discussed and resolved via email, teleconferencing, and video conferencing. Dispute resolution mechanisms are still open to resolve disputes in their unprecedented times. Whereas, on one hand, courts are resorting to virtual hearings, various forms of ADR, including arbitration and mediation, on the other hand, are being conducted online. So this is something which legal experts globally are suggesting online dispute resolution ODR to be the new face of the alternate dispute during this period of suspended hearing. And online dispute ODR, as it is known, is its broadest sense, refer to the internet, convenience, speed and convenience of the internet and ICT. Thus, ODR is merely an extended form of ADR, which derives its benefit from the ease and merely extended form of ADR with drive and adaptness of the internet and online communication. Now we are also seeing a lot of juniors adapting this technology, because I think they are more computer savvy than we are, and are not having any problems in undertaking this kind of conferencing and appearing before the courts through video conferencing or hybrid systems. So the basic online dispute is actually yet to become popular, but during as with the passage of time, I think we people have also taken it up, and the courts have also taken it up as a very successful awareness among technology, privacy and confidentiality of data, cybercrime, etc., to list a few. It's only a matter of time. I also feel that dispute resolution, India will adapt this new, modern, and much technologically driven technique. So in the end, to sum it up, I would say that this ADR is the need of the hour and should be followed by us. And if we get an opportunity to adapt this and to, thank you so very much. I hope I have been little clear in what I said, and you all must have understood have followed what I said. Thank you so very much for being patient in hearing.
That was an indeed a very exemplary explanation of the ADR system in which the present world is facing of the COVID pandemic situation, where the courts are not in reach of the is a cost-effective, mutually agreed upon, and both
I'm sorry, Mr. Somna, I would like to convey my thanks. And Keshav, I would like to thank Mr. Keshav Sharma from core of my heart for giving me an opportunity to be here on this platform. And I am a very hardworking boy, and he has a great future. So after learning, wants to impart training also. God bless you, Keshav, and to all of you, thank you once again from the core of my heart.
Thank you, sir.
Thank you so very much.
We are all blessed by your kind words.
Sir, thank you so much for being the shining light and taking the time out and conducting this session for us.
Pleasure is mine. Pleasure is mine. I will continue to be associated with you. Thank you so very much once again to all of you. God bless you. Once again, wishing you all a very happy
Thank you, sir. Thank you so much.
Independence Day. Thank you so much. Thank you.
Thank you.